So we talked about the 5 for the financial. Now we're going to go over the annual policy statement. I call them the administrative part of what we all do, how we put together all of the administrative notices for the association. So currently, some of the notices are actually required to be individually, thanks Mark, sent to the owners. I appreciate that. We have a new section, 5310. And this is our next exception. This requires the board to distribute by individual delivery the full annual policy statement. And what they mean by that is the cover sheet, not the statement, because the definition is all of the things. It's not properly worded in my opinion, but the cover sheet for what you're including in that annual policy statement, that has to go out by individual delivery, the statement or the summary of all of the documents that are included in the policy statement. This is a 30-90, no less than 30, delivered 30 to 90 days before the end of each fiscal year. And don't forget, 2 copies have to go out if the owner has a secondary address. And you're going to check your opt-in and opt-out list in case anybody is making demand off of your secondary address list as well. If a member wants the full shebang, they have the right for the full shebang. And the way the statute is worded, it says you cannot send them the summary. So I don't know what that means. It sounds like you're going to be punished if you do. But I don't think that's what the legislature meant. It just meant if somebody wants the whole thing, they have a right to it, send it to them. Otherwise, you're going to go ahead and send them the summary. The annual policy statement must include the association's designated recipient. It's one of the first things we talked about that. You're going to do that right away. It's a new requirement. We're going to be telling them about the right to the secondary address. You have to tell them you have the right to a secondary address for the purpose of the notices. This is on an annual basis. You have to make sure to say that to them. You don't have to follow up. You don't have to say, do you want to do it? You just have to, it's on them once you do that. General notice location. This is a 3 major double wow. Again, you must describe the location, if any, designated for general postings available for the members to see. It's supposed to be a place where people should be able to see it. And we all know if you have off-site owners, they're not going to be able to see it. But the legislature gave you this out, and we're going to do that. If you do not put it in your annual policy statement, you lose the right to do so and use that for the next year until you send out your next annual policy statement. You also have to send out a notice, and I'm not happy about this one, the right to receive general notice by individual delivery. So we have all of these great things. And then we have the homeowners that say, we want to receive general notice by individual delivery. So, of course, with this thing that I'm so excited about, my stick and the pole, if somebody says, I get individual, those 11 people, you can't count on them seeing it on the stick. They're still going to have to get individual notice. Don't be discouraged by that. Not a lot of people are going to make that demand on you, hopefully. We don't want that to be a big issue. Moving along, the right to receive board minutes. You must give the members notification. They have a right to receive a copy of the board minutes, and you tell them how and where. Assessment collection policy. You must provide the policy and the notice that's in 5730, section 5730. And don't forget, assessment collection policies are also distributed with pre-lien or intent to lien letters. Assessment default enforcement policy. This was 1365.1. And this is the statement describing associations' policies and procedures and enforcing lien rights or other legal remedies. And you can enforce this, you can put this statement within your collection policy. It's one that has to be at a certain font, 9 or 14. You told me yesterday, I forgot, Tracy. 14? 14? 14 font, but you can put this into the assessment collection policy. It does not have to be separate, but it does have to be mailed out on an annual basis. This is a change coming up. Governing document, enforcement, and fine policy. Currently, the statute says what on fine policies? If you have them, then you have to send them out. That's what it says. So that members will know what's going to happen to me if I'm bad. You now have to send out a discipline policy. The association must provide a discipline policy, and it still says, if any, a schedule of penalties. But if you don't send out a schedule of penalties, you can't fine a homeowner under a schedule of penalties. So basically, they didn't completely clear up the language, but they are saying you're not going to get to do that, to fine, if you don't send out the fining policy. Those of you that didn't know that, and that would be most of us, including myself, yes, if your boards aren't planning to meet again this year, this is a bit of a problem, but wait long enough and you can say it's an emergency, because you really want to get this information out, and you want them to approve this so you don't miss it in your mailing. So this is in addition to any other fine schedules that you have during the course of any particular year. Still have to have a summary of dispute resolution, that's 5,900, and you have to have architectural guidelines and procedures. This has a new change in it as well. The notice requirements for associations' approval of physical changes must include the type of changes that require approval, so the following things you have to submit architectural approval. And the new thing is a copy of the procedure used to review and approve or disapprove the change. This is required. The procedure used to review and approve or disapprove the change. Why is this a big deal? Because I hear at least once a week on something that comes into my office, and I'm only one lawyer of all the lawyers in my office, the board acted discriminatorily in not approving my architectural submission. And you're going to be in a world of hurt, you being our collective associations, if we don't have this policy and establish it. What do I think will happen? When we researched it, there was no "and if you don't, the following will happen." What's going to happen is we're not going to be able to enforce our architectural guidelines, is what's going to happen. So if you can't, the way the statute is written now, you say you aren't approved, you're supposed to tell them how you could approve. You can't approve no matter what because we never approve this. Or this needs to be a 5-foot setback. If you provide new plans, blah, 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 please resubmit and we will review. This is new, and we do need to tell them that procedure. Yes, Michael, and I will repeat the question.
In a lot of CC&Rs, there's just a blanket statement, owners shall make no structural changes without board approval. That statement has to be disclosed.
That statement has to be disclosed. Even though you're disclosing it in the documents, and every person who closes escrow in California says they have to receive the documents, and they all lie and say they have read them because you get them in escrow. But there are other ways to get property here. There's interfamilial transfers where you don't have to go through escrow, and people may not even know that there are governing documents, or they live in or have property in an association. So yes, it is unfortunate, but yes, you have to do that. Okay, overnight payment mailing address. I think we already have that in the code for overnight payment of assessments or any other language or information that has to be provided as required by other statutes as well could go into this package.